All right, Donald Trump thought it was over. The rallies were packed. The polls were shifting. The comeback story was writing itself in real time. And then, without warning, a federal courthouse door swung open, and everything changed. A legal challenge so immediate, so precisely targeted, that Trump's own legal team scrambled to respond within hours, not days, hours. The kind of filing that makes seasoned attorneys go quiet and reach for their phones. This isn't a political story. Stop thinking about red versus blue for a second. This is about a legal system that just got handed a loaded weapon, pointed it directly at a former president who is also the current president-elect, and pulled the trigger. And the question nobody wants to answer out loud is whether anyone at all, has the power to stop what comes next. Because here's what's already happening. Judges are being called in on weekends. Emergency motions are being filed in the middle of the night. Legal scholars who spent 30 years saying this scenario was impossible are now sitting in front of cameras trying to explain how we got here. And Trump, the man who has survived more legal attacks than any political figure in modern American history, is facing something different this time, something that doesn't have a clean playbook, something that even his most loyal defenders are quietly admitting could get very, very complicated. So what exactly is being challenged? Who filed it? And why now of all moments when the election dust has barely settled? That's what I'm going to walk you through. Because once you understand the full picture, once you see what's actually being argued in these courtrooms right now, the story becomes something far bigger than any headline has captured. Let's go back to where this really starts. Not last week, not last month. This thread stretches back years, woven through courtrooms and congressional chambers and backroom legal conversations that were never supposed to become public. But they did, because things like this always do eventually. The legal challenge now hitting Trump from multiple directions isn't a single case. That's the first thing people misunderstand when they scan the headlines. It's a constellation of interlocking legal questions, each one designed to exploit a different pressure point, each one timed with a precision that speaks to serious legal strategy behind the scenes. Whoever assembled this isn't improvising. This was planned. The central challenge involves something that legal scholars have been debating in academic circles for years. The fundamental question of whether a sitting president or a president-elect preparing to assume office can simultaneously face active criminal prosecutions, civil enforcement actions, and constitutional eligibility challenges without the entire legal apparatus grinding to a halt. In theory, the answer has always been complicated. In practice, nobody thought we'd actually get here. We got here. The moment that crystallized everything happened in a Washington, D.C. federal courtroom when a legal team filed a motion that essentially argued the following. The prosecutions against Trump weren't just legally flawed. They were constitutionally impermissible in a way that, if accepted by the courts, would unravel years of legal proceedings in a single stroke. Bold doesn't begin to cover it. Lawyers who read the filing described it in terms usually reserved for once-in-a-generation arguments, not because everyone agreed with it, but because everyone understood what it meant if even part of it held up. The legal architecture being challenged is enormous. Think about what's actually at stake and let the scale of that settle in for a moment. Multiple federal cases, state-level prosecutions with their own timelines and their own judges and their own evidence trails. Civil liability questions, still echoing from New York. And now, layered over all of that, a fresh constitutional challenge that targets the very foundation of whether these cases can proceed at all. Trump's legal team didn't just respond, they counterattacked. That's the only word for what they did. Within hours of the initial filing, a response brief arrived that was surgical in its precision. Every argument addressed, every precedent cited, and at the center of it, a claim that sent the legal world spinning. The prosecution of Donald Trump, they argued, represents the single most dangerous assault on the separation of powers in American legal history. Strong words. The kind of words that either look prescient or reckless, depending on how the judges respond. Here's where it gets complicated in a way that most coverage is glossing over completely. The judges assigned to these cases aren't blank slates. They have records, they have philosophies, they have prior rulings that legal experts have spent weeks analyzing for signals about which way they might lean. And what those experts are finding isn't a clear picture. It's a battlefield. Some of these judges have signaled deep skepticism about the prosecutorial approach. Others have signaled the opposite. And the cases are moving through different courts simultaneously, which means you could get conflicting rulings from different judges on questions that are essentially the same constitutional issue. That kind of legal chaos doesn't resolve cleanly. It escalates. Conflicts between courts get pushed upward. Upward means the appellate level. And at the appellate level, you start approaching territory where the Supreme Court becomes relevant. Are we heading toward the Supreme Court on some of these questions? People who do this for a living, people who have argued before the Supreme Court, are no longer saying no when you ask them. They're pausing, they're choosing their words carefully. They're saying things like, it's not impossible to imagine a scenario where certain questions reach that level. That's lawyer speak for yes. Let me tell you about the specific challenge that's generating the most internal panic among the prosecution teams. Because this is the one nobody saw coming, even the people who thought they'd seen everything. It's built around a legal theory concerning the nature of presidential immunity and how it interacts with criminal prosecution timelines. The Supreme Court already weighed in on presidential immunity in ways that reshaped the legal landscape significantly. Trump's legal team is now using that ruling as a lever, arguing that the implications haven't been fully applied to the existing cases, that entire categories of evidence need to be re-examined through the new immunity framework, and that doing so properly would require reopening proceedings that prosecutors considered closed. In plain English, they're arguing that the Supreme Court's own ruling created a requirement that nobody has fully honored yet, and that fixing that oversight would be enormously damaging to the prosecution's case. The prosecutors are furious. And their fury is visible in the filings, which is unusual. Legal documents are usually dry and procedural. These aren't. You can feel the frustration bleeding through the formal language. Their argument is that this immunity application is a deliberate delay tactic, a procedural weapon designed to run out the clock, to push these cases past the point where they can practically proceed. They might be right. They might be right, and it might not matter. Because in law, the validity of a tactic and the legitimacy of the underlying legal argument are two completely different questions. You can be strategically cynical and legally correct at the same time. Courts have to respond to the argument on its merits, regardless of the motivation behind it. And here's what's really keeping prosecutors awake at 3 in the morning. The immunity argument isn't obviously wrong. It's uncomfortable. It's inconvenient. It cuts against the narrative of accountability that drove these prosecutions from the start. But it's not obviously wrong. And when a legal argument isn't obviously wrong, courts have to take it seriously. That's how the system works. That's also how things get very complicated very fast. Now, here's the part of this story that I haven't seen any major outlet actually tackle head on. And it's the part that matters most for understanding where this is going. The timing of this legal challenge is not accidental. Nothing in high-stakes federal litigation is accidental, especially when the case involves this level of resources, this level of talent on both sides, and this level of political consequence. Somebody made a decision about when to file, and that decision reflects a calculation about the current environment. What is that environment? Think about it carefully. Trump has won the election. He is preparing to assume the presidency. His administration will control the Justice Department. Cases brought by federal prosecutors exist within a department that will soon report to a president who is also the defendant in those cases. The constitutional and practical questions that creates don't have clean answers. Legal scholars are divided. Historical precedent doesn't fully cover the scenario. And the window between now and Inauguration Day is a narrow, turbulent corridor where an enormous amount can happen very quickly. The legal challenge filed now is designed to operate in that corridor, to create maximum procedural disruption during the period of maximum institutional uncertainty, to force courts to make decisions under time pressure that they would normally take months or years to work through carefully. It's a strategy, a high-risk, high-reward legal strategy that could either collapse all the cases against Trump into procedural chaos or get swatted down definitively and leave the prosecution on stronger ground than before. Former federal prosecutors who have no political stake in the outcome, are split almost exactly down the middle about which way it goes. That should terrify everyone who wants a clean resolution. On either side, let me tell you about the human element here, because it's getting lost in the legal architecture, and it shouldn't be. There are career prosecutors who have spent years building these cases. Not political operatives, not partisan warriors, just lawyers who were handed a file and told to follow the evidence wherever it led. They followed it. They built cases that, on the pure legal merits, independent of any political consideration, represent serious, documented, extensively supported allegations of criminal conduct. Those people are now watching a legal challenge designed specifically to neutralize their work, and they're doing something that lawyers aren't supposed to do in public. They're showing their anger, not in press conferences, but in the filings themselves, in the sharpness of the language, in the speed of the responses, in the barely contained frustration visible to anyone who reads these documents with fresh eyes. At the same time, there are defense attorneys on Trump's team who have spent their careers doing exactly what defense attorneys are supposed to do: protecting their client, testing every argument, exploiting every procedural option available under the law. That's not corruption of the legal system. That's the legal system working exactly as designed. The adversarial process depends on both sides fighting as hard as they can. The problem is that the legal system was designed to handle normal defendants, people without the power to pardon themselves, people who can't install loyalists in the very agency prosecuting them, people who, when found guilty, can't simply change the laws that govern their prosecution. This is not a normal defendant. The system is straining against that reality in real time. And here's the thing that cuts through all the partisan noise and makes this a genuinely difficult constitutional moment, regardless of your politics. What happens to the precedent? Every decision made in these cases, every ruling, every motion granted or denied becomes precedent. It becomes the thing lawyers cite in future cases. It becomes the framework within which future prosecutions of future powerful people get evaluated. The Trump cases, whatever you think of Trump, whatever you think of the prosecution, are going to shape American law for a generation. If courts rule that a president-elect's transition period creates a zone of immunity, that's precedent. If courts rule that the immunity framework means prior evidence categories need to be re-examined, that's precedent. If courts rule that a sitting president cannot be prosecuted for certain categories of conduct that occurred before taking office, that is enormous precedent. It doesn't just apply to Trump, it applies to every person who ever holds that office going forward. Legal scholars who oppose Trump politically are losing sleep over this, because they can see a world where the right legal argument made at the right moment, in the right court, produces a ruling that they hate in the immediate case, but which fundamentally alters the legal accountability framework for American presidents in ways that will outlast everyone currently arguing about it. That's the hidden horror of this situation. The precedent risk runs in every direction. Now let's talk about what the courts are actually going to do, because the speculation and the fear and the legal theory all eventually crash into reality at the moment a judge puts pen to paper. The judges handling these cases are in an extraordinarily difficult position. They are being asked to make decisions under time pressure, in a politically charged environment, on constitutional questions that don't have settled answers. Whatever they decide will be criticized savagely by one side of the political divide. They know that going in, career federal judges are used to making unpopular decisions. But there's a difference between an unpopular ruling in a complicated corporate case and a ruling that puts your name permanently in the middle of one of the most divisive political events in modern American history. Some judges have already shown their cards. One judge, faced with an early motion in the new challenge, rejected it in language that was unusually blunt for a federal ruling. Unusually blunt. The kind of language that signals a judge who is not impressed, who is not sympathetic, and who is not interested in procedural games. That's a signal. Whether it holds through the full case is a different question, but it's a signal. Other judges have been more measured, more careful in their language, more willing to entertain at least the possibility that the new arguments have merit worth examining. When a federal judge says an argument has merit worth examining, Trump's legal team sends that sentence to every relevant outlet within the hour. Because it matters, because it shapes the narrative, because the narrative shapes the political context inside which these legal proceedings occur. This is another thing that most coverage misses. These cases don't exist in a vacuum. They exist inside a political environment that affects them constantly. Not in the sense of corruption, but in the more subtle, more pervasive sense that the people making decisions about these cases are human beings living in America in 2025, reading the same headlines everyone else reads, aware of the political temperature, aware of what their rulings will mean beyond the immediate legal questions. They're not supposed to factor that in, but they're not robots. And pretending otherwise is a kind of willful naivete that doesn't serve anyone. Here's what we know is coming. based on the current trajectory and the filings already on record. The immediate legal challenge will produce rulings within weeks, not months. The timeline is compressed by the nature of the motion and by the judge's own stated desire to move these cases forward. Those rulings will be appealed immediately by whichever side loses. The appellate courts will face the same time pressure with an additional layer of complexity because they're reviewing rather than deciding from scratch. And throughout all of this, the clock keeps ticking toward January 20th. After January 20th, the federal cases enter genuinely uncharted territory. A sitting president, previously indicted, now holding the power of the executive branch. There is no established legal answer to what happens then. There are opinions, there are theories, there are law review articles arguing 20 different positions. There is no settled law. The state cases are somewhat different. State cases don't fall under federal executive authority. A president cannot pardon himself from state charges. But state cases have their own complications, their own judges, their own political environments, their own procedural vulnerabilities. They move more slowly, they're more susceptible to delay, and delay in this context serves one side of this conflict much more than the other. Everyone who has spent any serious time analyzing this situation reaches the same uncomfortable conclusion. The most likely outcome in the near term isn't resolution, it's prolonged uncertainty. Legal trench warfare conducted simultaneously on multiple fronts, with neither side achieving a decisive victory, with every ruling producing 3 more motions, with every development generating a counter-development. The system was built for this kind of sustained adversarial combat. That's the version of the rule of law that drives the legal challenges. It's also a principle with deep roots. It's also not wrong. When 2 legitimate expressions of the same principle collide at this level of force, the collision produces exactly what we're watching right now. A legal system straining at its seams, being tested in ways it has never been tested before, with enormous consequences riding on every decision. The people who built this system, the founders who wrote the Constitution, the framers who established the federal judiciary, the generations of lawyers and judges who built the precedent structure, none of them fully anticipated this moment. They anticipated abuse of power. They anticipated contested elections. They anticipated powerful individuals who would resist accountability. What they didn't fully anticipate was a moment where the accountability mechanisms and the democratic mechanisms would collide so directly with such force at exactly the same time. We're in that collision now. And here's the part that I genuinely don't know how to resolve. The part that I suspect nobody does. Whatever happens in these courtrooms over the next 60 days will be called a victory by one side and a travesty by the other. That's guaranteed regardless of the outcome. If the challenges succeed and the cases are disrupted, Trump's supporters will call it vindication and his opponents will call it the death of accountability. If the challenges fail and the prosecutions continue, Trump's opponents will call it justice and his supporters will call it persecution. The polarization is so complete that the actual legal reasoning, the actual constitutional analysis, the actual merits of the arguments will be almost entirely invisible in the public conversation. That's dangerous, not because it affects the cases in the immediate term, but because it affects the institutional legitimacy of the courts in the long term. When people stop believing that courts are neutral arbiters and start believing they're just another political battlefield, the entire framework of legal accountability begins to crumble. Not all at once, slowly. Erosion doesn't announce itself. But I also know this. The people actually making these legal decisions, the federal judges sitting in courtrooms that most people will never set foot in, are reading the arguments, they're studying the precedents, they're engaging with the constitutional questions seriously, the way those questions deserve to be engaged with. And that matters. It matters more than any headline. It matters more than any rally speech or fundraising email or cable news segment. The law in the end is what the judges say it is. And the judges are still working, still reasoning, still deciding. Whatever you think of Trump, whatever you think of these prosecutions, whatever political team you're on when you close this window, that's the thing that keeps me coming back to this story when I could look away. Not the drama, not the personalities, not the political stakes, as enormous as they are. It's the constitutional moment, the genuine, unrepeatable, historically significant moment we are living through right now, where questions that have never been definitively answered are being forced toward answers by the sheer weight of events. History doesn't wait for convenient moments. It doesn't schedule itself around election cycles or campaign strategies or legal timelines. It just arrives. And then everyone has to deal with what it brought. What it brought this time is a legal challenge that cannot be easily dismissed, targeting a political figure who cannot be easily prosecuted, in a system that was not fully designed for this scenario, at a moment when the stakes for American democracy are as high as they have been in living memory. The next ruling drops soon. Maybe days, maybe hours, if the judges move at the pace they've been telegraphing. When it does, the next wave begins. The next motion, the next appeal, the next late-night emergency filing that sends everyone scrambling again. Watch the filings, not the press conferences. Read the rulings, not the summaries. Pay attention to the language the judges use, because that language is doing more work than it appears to be doing. It's signaling, it's framing, it's laying groundwork for what comes next. Because what comes next is coming regardless of whether anyone is ready. The legal machine is in motion. The constitutional questions are in front of the courts. The precedents are being written in real time. And somewhere in a federal courthouse that most people couldn't find on a map, a judge is writing the sentence that will determine whether accountability in America still means what we always told ourselves it meant. That sentence is almost finished. And when it drops, everything changes. Again, the appeals are already being drafted. Before the ink is dry on the ruling, before the news alerts have finished pinging on everyone's phones, the legal teams on both sides will have their next moves ready. That's how prepared they are. That's how much is riding on every single word that comes out of these courtrooms. But here's what nobody is telling you about what happens in that immediate aftermath. It's not the lawyers who matter most in those first hours. It's the markets, it's the banks, it's the institutional money that has been quietly watching this case from a distance, calculating risk, hedging exposure, waiting for a signal about which way the wind is blowing before making decisions worth hundreds of millions of dollars. The moment that ruling lands, financial institutions that have spent months pretending this is someone else's problem will suddenly have to make choices. Public choices, the kind that end up in quarterly filings and board meeting minutes, the kind that can't be walked back. That's the part of this story that has barely been touched, the financial contagion risk. Because Trump's business empire doesn't exist in isolation. It's woven into deals, partnerships, licensing arrangements, and debt structures that connect to institutions who absolutely cannot afford to be seen as complicit in whatever a court has just labeled as fraudulent or unconstitutional or both. Watch the bank statements. Watch the institutional distancing. Because that quiet financial retreat, the one that happens in boardrooms and not on television, will tell you more about where this is actually heading than any legal filing ever could. And Trump knows this. That's what makes his continued aggression so fascinating to watch and so strategically risky at the same time. Every attack on a judge, every social media post calling the process corrupt, every rally speech framing the legal system as a political weapon, it plays brilliantly to his base. The donations confirm that, the crowd sizes confirm that, but it does something else simultaneously. It keeps institutional money nervous. It keeps corporate partners calculating exit strategies. It keeps the business world, the world Trump spent 4 decades building his identity inside, at arm's length. You cannot fight a legal war this aggressively in public and simultaneously reassure the financial community that everything is under control. Those two things don't coexist. And the longer this continues, the more that tension compounds. There's a breaking point somewhere in this story. There always is. A moment where the legal pressure, the financial pressure, and the political pressure reach a combined weight that forces a decision that changes the entire trajectory. We haven't hit it yet, but we are closer than any public statement from either side would suggest. The courthouse doors are still open. The judges are still working. The lawyers are still filing. But the clock that matters most isn't the legal calendar. It's the one nobody can see. And it is running out faster than anyone is admitting. And that's where we are right now. Standing at the edge of something that has no historical blueprint, no clean precedent, no guaranteed outcome. The legal battles will continue, the rulings will drop, the appeals will follow. But here's what I need you to understand before you close this video. What happens in these courtrooms doesn't stay in these courtrooms. It comes home. It shapes the country your children inherit. So stay informed, stay engaged. Don't let the noise drown out the signal. If this video opened your eyes to something the headlines missed, hit that subscribe button, because this story isn't over, not even close.